Good evening, everyone. My name is Ron Hood, and I am one of the three co-chairs for the Constance Baker Motley series. It is my pleasure to welcome you all to tonight's session. The Constance Baker Motley series on racial inequality was established in 2020 as a collaborative project between the Connecticut Bar Association and the Connecticut Bar Foundation. The series is an ongoing forum for the legal community and others to explore issues of racial inequality, systemic racism, all while advancing civil rights and social justice. Constance Baker Motley was a trailblazing civil rights attorney born in New Haven, Connecticut in 1921. She went on to attend Fisk University, New York University, and Columbia Law School. She was hired by then attorney Thurgood Marshall to work for the NAACP Legal Defense and Educational Fund, where she wrote the original complaint in Brown versus Board of Education and became the first Black woman to argue before the U.S. Supreme Court in Meredith versus Fair. She went on to argue a total of 10 cases before the United States Supreme Court. And in 1966, she became the first Black woman to serve as a federal judge. She continued to serve the court until 2005, when she passed away at the age of 84. And throughout her life, she maintained a strong connection to Connecticut. Today's session is titled Disparate Outcomes in the Criminal Court, the Role of Prosecutorial Discretion. Prosecutors possess extraordinary discretion in deciding which cases and charges to pursue, as well as which alternatives to consider. The exercise of this discretion plays a significant role in determining who ends up being convicted and for how long individuals are incarcerated. Tonight's program will explore this prosecutorial power, discuss relevant Connecticut statistics of criminal justice outcomes, and examine the important role of prosecutorial discretion in reducing the disparate racial impact in the criminal justice system. Now, without further ado, I will turn the program over to Attorney Moy Ogilvie, who co-organized tonight's program and will introduce tonight's moderator and featured speaker.
Thank you, Ron. Good evening, everyone. On behalf of the Planning Committee, we are thrilled that you attended today, and our Planning Committee is grateful for Justice Harper's willingness to serve as the moderator of tonight's program. So by way of background, the Honorable Luby Harper Jr. is a graduate of the University of New Haven, UConn School of Social Work, and UConn School of Law. He was in private practice for about 20 years. When he was in 1997, he was appointed as a judge of the Connecticut Superior Court. In 2005, he was elevated to the Connecticut Appellate Court, and in 2011, he was elevated to the Connecticut Supreme Court. After his tenure on the Supreme Court, Justice Harper has sat by designation on the Appellate Court. He currently serves, and since 2006, has served as the chairman of the Connecticut Commission on Racial and Ethnic Disparities in the Criminal Justice System. Justice Harper has been involved with too many bar associations and nonprofit organizations to list. He has been the recipient of numerous awards throughout his distinguished career. We are thrilled to have him with us tonight, and I now turn the program over to the Honorable Justice Harper.
Good morning, good afternoon, everyone. Thank you, Moy, for that wonderful introduction, and I'm certainly pleased to have the opportunity to participate in this program. It's certainly a worthwhile program and involves a topic that is near and dear to my heart. I'm looking forward to a productive session where we discuss some issues that need to be discussed. And hopefully, as a result of this program, Connecticut could move forward in terms of how it addresses disparity within our criminal justice system. So at this point, I'd like to introduce Mark Halko. Mark will present some information. And Mark is the Undersecretary of the Criminal Justice Policy and Planning for the State of Connecticut, Office of Policy and Management. And I think Mark, along with Kyle Buden, will present some information, relevant information, I might say, with respect to historical background regarding data collection in Connecticut and how that might interface with what we're trying to do in terms of analyzing the use and prosecutorial discretion in Connecticut. Mark?
Thank you very much, Justice, and many thanks to Attorney Ogilvy and for all the organizers of tonight's session. Hearing about the legacy of and the intent and the meaning and the lofty goals of these sessions certainly is one that moves me deeply and humbles me too. And I hope that I can be of value to the work tonight. The Office of Policy Management has produced reports involving prosecutor data analysis. And I think the origin of these reports is the national conversation happening involving the role of prosecutors in the criminal justice system. Key questions being asked over whether prosecutors are the driver of incarceration or are they the key to reducing incarceration. My sense is that prosecutors are neither the sole driver nor the sole key, but they can have enormous impact within the criminal justice system in achieving the shared goals of less crime, fewer victims, less recidivism, less disparity, more effective use of system resources. Prosecutors have considerable impact on the outcome of all cases disposed of by the court. Aspects of the cases including the handling of docketed charges, bail, diversion, discovery, case processing, pleas, sentencing. But prosecutor actions depend on interactions with others involved in the case, the participation of the victim, the actions of the defendant, the work with the defense attorney or public defender, and the ultimate decisions that are made by the judge in executing the case. So I think that shows both the significant impact that prosecutors have, but reflects the role they play within the larger system. And there's something interesting I wanted to note that I think many of us are aware of is that Connecticut is one of, I believe, 5 states in the country where prosecutors are appointed, not elected. And of those 5 states, Connecticut is the only one where prosecutors are appointed by an independent commission. The other 4 are appointed by the governor or by the attorney general. The fact that I think prosecutors contribute to, but don't necessarily execute outcomes of cases can make it hard to find and assess the impact of their work on cases using data analysis. Prosecutors across the country are stepping up by establishing dashboards and reporting and providing analysis. But it's different when you're looking at prosecutor data compared to other sources of information that we can get involving, for example, reported crime, arrests, prison admissions, prison releases, parole board decision-making, case dispositions from the court. Those are all tied to specific actions and decision points that are made. And I think our challenge in producing these reports has been, how do we capture the work of a prosecutor? That's been the initial charge of the reports that have been completed, is actually capturing the work as it lands on prosecutors' offices and trying where we can to estimate the impact of prosecutors on the outcomes of those cases. Our reports have included analysis of all cases disposed of by the Connecticut court system in a given calendar year. Large data set, a lot to work with and analyze and try to produce information. It does make it challenging, however, to get to the depths of actually capturing the impacts of prosecutors on cases. But I do believe that the work done so far complements ongoing initiatives, such as the work that Justice Harper does on the Commission on Racial Disparities, other studies that are carried out in Connecticut. It fills in that gray space that exists around the work of prosecutors. So I like to focus on the cases as they hit and land on prosecutors' offices in Connecticut. In calendar year 2021, the Connecticut court system disposed of almost 99,000 cases. Those cases included approximately 230,000 associated charges, and they involved approximately 67,000 people cases disposed of. The majority of those cases had a misdemeanor as the most serious charge, 71%. Another 19% involved felonies, and another 10% involved infractions. Now the felonies, they skew toward the lower level felonies, the felony D, for example. I think this is important because it shows you the type of work of cases that land on prosecutors' desks in terms of the severity of the charges. I often look at prison populations and impacts on there, and that's a small segment of the entire universe of charges. and case dispositions that reach our court system. It's a much larger volume of cases that you can impact to achieve the goals of less recidivism, lower crime, addressing disparities in the criminal justice system. GA courts in Connecticut handled 95% of those charges, far and away the vast majority. JD courts handled about 2% of the total cases, and our community courts in Hartford and Waterbury handled 3%. JD courts typically are the most serious, most complex, most long-lasting cases in general. There's no specific line that separates them from the GAs. There's also some complexity in the cases. Although 75% of them involved a person with a single case, 25% of the, actually 23% of people receiving a case closure had between 2 and 5 cases closed in that given year. And 2% had 5 or more. So you can imagine the workload involves complexity of handling people with charges and cases that may be in that GA, multiple GAs, and trying to work through those and find a suitable resolution. Next, some information on the outcome of cases. 59% of cases disposed of in 2021 calendar year were nollied. Nollie is important for the work of the prosecutor because it involves the prosecutor's decision not to prosecute the case. There are shapes and forms of nollies in states across the country. I think the fact that Connecticut, all arrests that are filed with the court are docketed means the nollie is even more important. The cases have been docketed. The prosecutor will open up the case and work through it. There is no decline to prosecute a case that is available in most cases. So the nollie is very important from that perspective. I believe it also encompasses the prosecutor-led diversion, the work that a prosecutor does on a case to reach a decision that this case does not need to proceed. So I place great emphasis on the 59%. Within that same calendar year, 27% of cases received a guilty disposition, and 18% involved a dismissal. That nollie percentage is actually up by 13% compared to the prior 2 calendar years. A charge resulting in nollie in the vast majority of cases will lead to a erasure of the case, so long as a person doesn't receive another arrest or some other circumstance during that time period. So it's a powerful tool to enable people touching the court system to emerge without that long-lasting criminal record. The nollie took a median of 8 months to close from opening, which suggests to us the work that's done through continuances, through interactions between the prosecutor and the defendant. Only a small percentage of the nollies were nollied at the very first appearance. There's a shortage of data on nollies. I mentioned the wealth of data we swim in of case dispositions, but those are data managed by the judicial branch. So it's managing judicial branch data and their books of business. We had to turn to qualitative analysis of prosecutors to talk to them about the nollie. And what we heard from them is that they typically employ different techniques to work with defendants. They will monitor the defendant's treatment or program participation. They will mediate between victim and defendant. They'll work to get the person compliant again with any motor vehicle issues they might be having. But we don't have any data on that. So prosecutors can't show their work about the impact that they may be having on the nollies of cases. By contrast, we know a lot about dismissed cases in the judicial branch. We know that of the cases that include a referral to a state diversion program, they're far more prevalent in the dismissed cases. Alcohol education, family violence, accelerated rehabilitation. So the court can point to work done with defendants on referrals to these programs prior to the dismissal of the case. But with the prosecutors, there is not currently complete data available to look at the work that was done or to explore those decision points that exist when a prosecutor is working with the defendant to ultimately render the nollie. On demographic analysis, key question we're often asked in the reporting is, what is the impact of prosecutors on the well-documented disparities in the criminal justice system? With the data set that we have, we analyzed and compared proportionality of demographic groups, Black, Hispanic, white, and other demographics of the resident population in Connecticut to cases disposed of by the court. And we found overrepresentation of Black or Hispanic defendants, of cases disposed of relative to the state population. And the reverse was true for white or other individuals. Did prosecutors contribute or cause this? That is not something that we've been able to analyze because the studies that we're performing are using descriptive statistics of cases disposed of by the court. Deeper analysis will be required to determine the answers to that question. Next question is, do prosecuted cases differ based on defendant demographics? Because we know case dispositions, we could look at, of people receiving a case disposition in 2021, how did the percentages vary by demographic groups? We saw that a greater proportion of people receiving a disposition who are Black or Hispanic received a NOLI compared to white or other defendants. And the reverse is true for the guilty cases. But we're not able to develop a quasi-experimental study that could control for different variables in the case. We have very limited information about the case. We're not able to control those variables. And in areas where there seems to be encouraging news about cases and disparity potentially impacted by prosecutors, we can assign a correlative or a causal link. That's an area of limitation for the analysis where we can show as necessary, as appropriate, demographic compositions of the populations, and we can show disproportionality or proportionality and where that lies. And I think that's important to complement the work that's being done across Connecticut's criminal justice system on analysis. But there is not the ability to focus on prosecutors and the work they do and the impact they may or may not have on disparity. That's a limitation of it. I think that the next presentation you may be hearing from could explore these matters a little bit further, but I did want to be clear about the limitations of the study. The studies that we've been able to do have provided intensive analysis of prosecutor workflow and cases that move through their offices. And I think it creates a platform for, as more data become available, that deeper analysis can be provided that will answer some of the key questions that people are rightfully answering by the studies that are being carried out on this work. I wanted to emphasize that I think there's some concluding thoughts about how these reports that our division has worked on have developed. It began as a proof of concept. With significant data from the judicial branch, where do we begin to explain the work of prosecutors? Our first year was a proof of concept. Our second year was a comparison of those analyses within a pandemic year of 2020, the biggest impact that occurred. And 2021 is our effort when we present the report to the Criminal Justice Commission, which is the commission that appoints prosecutors in November, is to distill that information into a report, a condensed report, as opposed to a PowerPoint. My feeling is that as more data and rollout of the prosecutor's electronic case management system proceeds, it will provide significant more data to be analyzed. Plumbing the depths of the use of the NOLI and exploring those cases that received it, looking at the non-judicial sanctions that prosecutors applied, exploring much more about their work, and it'll capture the impact of prosecutors on the outcomes of cases. Whereas right now we're at the surface level, looking at the overall handling of cases from the entire court system. There's so much more that's possible when you go deeper. And that data will help prosecutors to explain their work at every level. Development of policy and budget, talking to the media, explaining their work, from a Department of Criminal Justice level, looking across the entire state, the 13 JDs, within each state's attorney's office, and also prosecutors. Having that data can show and reflect the important work that prosecutors do in impacting recidivism, crime reduction strategies, disparity, and so much more. It can provide instant levels of information to provide feedback on the decisions that are being made every day across our state and impacting the people of the state. It'll also help to inform future strategies for prosecutor-led impact on those lofty goals that I mentioned earlier on. It can use a framework for how to inform the development of new initiatives and policies and budget investments where prosecutors and the impact they have on cases can be the key to achieving the goals that I think all bring us together for sessions like this. So I hope that's a helpful time that I've had so far to go through the analysis conducted by the reports, and I hope that there's a complementary nature that I can serve to our following presenter from the Division of Criminal Justice Research, who can perhaps delve into some of these similar topics and others to provide information to you as a broader platform for our work tonight. Thank you.
Thank you very much, Mark, for such a enlightening presentation. And I'm sure we've gained a lot based on your description of some of the work that you're doing. It's very impressive, and we want to thank you. Now it's my pleasure to introduce Kyle Bowden. Kyle is the Manager of Research and Planning for the Division of Criminal Justice. I might note that Kyle was a former academic and also a police officer. Now he's with the Division of the Planning Division of the Connecticut State Office of Policy and Management. During his tenure at OPM, Kyle developed into the lead researcher behind Connecticut's annual recidivism report and prison population forecast, as well as the principal author of the monthly indicator report. In 2021, Mr. Bowden became a manager of research and planning at the Division of Criminal Justice. He studied political science and public policy at Louisiana State University before serving as a police officer and a detective for a decade. Kyle, it's my pleasure to introduce you. The floor is yours.
Thank you, Justice, and thank you everyone for having me here and allowing me to present some data and a few slides. I'm a little different than Mark. I hope everyone can see the presentation. It should be a title page showing Connecticut Bar Association Motley Speaker Series on your screens. Being more visual, I'm going to walk through these slides and try to describe some of the things that that Mark was discussing. He and I have worked together over the years in crafting the reports that he referenced. And before my time here at DCJ, I worked with Mark at OPM and was able to see this work firsthand and understand what goes into it. I wanted to share this with you because there will be an exam to get your CLE credits, and you'll have to be able to represent this slide at the end of the test. I'm just kidding. But as a visual person, what I like to do is construct a model of what is going on within a system so I can better understand it. And through this visual assistance, I can then see where the decision points lie and where any levers or change can take place that can make improvements or lead to positive outcomes. And there's an old saying, though, in the statistician world that all models are approximations, but some are useful. That is also the case with this very basic model of the cases as they flow through the criminal justice system in Connecticut. At the top, we see cases that are put into the system, arrive there through an arrest. They all go through an arraignment process and then have continuances, or most have continuances for plea or discovery. And then we have the various dispositions for each case. Most cases that receive a dismissal on the far left side go through a program diversion. To receive a nollie disposition, as Mark so eloquently described, there are many facets to that. This model focuses on the non-judicial sanctions, or to term it another way, prosecutor-led diversion that can achieve that disposition on cases. Or there can be a plea agreement on a case that can end in a conviction, a guilty plea, and a much smaller subset of cases that go through trial. Now, this diagram is not meant to be built to scale. It doesn't represent the numbers, but I will get into a few metrics down the line from this. And to take this seemingly complex model, I decided to try to boil it down into some more essential components. What are the things as a researcher I think makes sense to look at to try to understand what goes into those three outcomes that we described in the prior slide? How do we achieve a nollie, a conviction, or a dismissal on a particular criminal case? And in talking to prosecutors and people on the criminal justice system, these are the sort of the three main buckets of information that are thought about when cases are processed. Going through the first one, the seriousness of the offense, and the various sub-variables that go into this sort of global variable are listed in the bullets on the left-hand side of the screen. And what I did was, as Mark described, analyzing calendar year 2021 data, which is the first data coming out of the global pandemic we just experienced. I wanted to share some of that information with you in a visual form. And the chart on the right shows the conviction rate by charge severity. Now, this is the severity of the charge on the case as it was introduced into court. but these cases were disposed of in calendar year 2021. And we see a fairly clear relationship between the more severe the charge, the more likely that the case ends in a conviction. And throughout this presentation, I'm going to focus on conviction rates. I think that is something that we're very interested in. Mark was really talking about the NOLI, which I think is a very important thing to talk about, and really gets into the heart of prosecutors' discretion in terms of case outcomes. But I think that there's an interest in knowing about cases that result in convictions for defendants in our system. So I'm going to focus on those more specifically. Prosecutors often discuss and talk about the strength of the case that they have before them in court, and they weigh that case individually and decide, is there enough evidence to prosecute? What does that look like? What sort of components do I have to back up this prosecution? Unfortunately, the judicial branch, who provides most of this data, does not really capture anything that related to strength of case. And so we don't have much to describe here. But again, the sub-variables, if you will, are along the left on the slide. And now we turn to the defendant, the third and final component that's sort of often referred to by prosecutors, what their considerations are when cases are before them. And so of the data that are available, I look through which of these bulleted items I could put my hands on to try to think about and compare against the cases that were disposed in calendar year 2021 and what might have had an impact on those case outcomes. And the one that is not readily available, but is somewhat available through some data analysis, is linking those defendants whose cases were disposed of in calendar 2021 with their prior conviction history. And that takes some matching. And this is maybe a bit in the weeds for this discussion, but the judicial branch collects its data around the docket number, the case number, the individual case, not the individual defendant. And so we have to do some data work to connect the individual people across various cases. As Mark described, there were nearly 98,000 cases disposed against about 67,000 individual defendants in calendar year 2021. That number of defendants is a bit of an estimate because we have to find ways to identify people using inexact methods, date of birth that can be mislabeled, or other identifiers that aren't quite entered accurately. So we decided to look at conviction rates and defendant characteristics. And then these two charts laid side by side. The chart on the left depicts the conviction history of the defendant, whether they had no prior convictions, whether they had a prior non-felony conviction, or they had a prior felony conviction, and whether they were convicted on the case before the court in calendar year 2021. And as a data person, I'm looking for variation. I want to see where there's difference between the different metrics that we're looking at. And clearly to me that there's a relationship, a correlate at least, certainly nothing that can get into any sort of causation. That the prior history of the defendant seems to be a big driver in whether their case becomes they receive a conviction on their current case. And as I wrote in the slide, and I'm reluctant to read slides, but it's sort of what it is. These cases are very complicated things. And to find the data to explain the why and not just the what of what happened is very, very difficult to find in electronic data across a large number of observations. And so what we really do need, and Mark hit on this and he was accurate as can be on it, is that we need I'm a researcher, but I work within a state agency. I'm interested in operations and how we process cases and what goes into that. I'm not an academic, although I was one in a former life. And I really think our academic partners would be helpful to add some sophistication and nuance to the methodologies that we use to try to sort of unpack all of this information. And so what this slide does is sort of marries the two slides before, right? So on the left, you have the conviction history of all defendants. On the right, you have the race and ethnicity of the defendants and the conviction rates by those numbers. Here, we see the conviction rate with a clustered column of each of those race and ethnicities. And we see a very strong relationship. If you're an African-American defendant and you have no conviction history in 2021, you were convicted at a 19% rate. If you have a prior felony conviction, it's 44%, which is very similar to what we see for Hispanic defendants and white defendants across these various metrics. I thought it was important to bring that together. As Mark alluded to, and rightfully so, the disparity in the system is really in the sort of the volumes and the representation among these various racial and ethnic groups from our statewide population as compared to those who are currently in the criminal justice system and are having cases heard. This is the column on the left is statewide population data collected from the 2020 census. There's been a preliminary release of information for redistricting purposes, and I use that information to compare against the 2021 cohort of people who had cases disposed in the criminal courts. And we see that 63% of the statewide population is white, whereas 40% of defendants were white. 10% of the statewide population was African American or Black, 28% of defendants were Black. And this really goes into the sort of the volumes of the people in our court system and how they don't reflect the population of the state as a whole. And so I wanted to also to end with this and just to show these are essentially pie charts in bar form. And so on the far left, we have of those defendants with no prior convictions, what percentage of them were identified as white, African American, or Hispanic. And on the far right, those with a prior felony conviction that we could identify in the data, what percentage of them were represented as white, Hispanic, or Black. And we see that there's an inversion here, there's a discrepancy, and that white defendants tended to not have a prior conviction, whereas they were less represented in the prior felony conviction bucket, which gets into a whole nother question about a longitudinal study and thinking about these groups across time as well as within a single calendar year. And I know I rushed through these and I tried to cover a lot of ground very quickly, and I hope the visuals were helpful for some of you. But that will conclude the data presentation that I'll give from the DCJ point of view. Thank you, Justice Harper.
All right. Thank you so much, Kyle. We really appreciate your presentation. Certainly, data collection is very, very, very important, and having an appropriate case management system is important so that we can analyze the data that's collected, so that we can determine what we're doing, what we're doing that's working, what we're doing that's not working, what we can do to eliminate disparity wherever we find it. And so I think your presentation is helpful. And certainly as we go forward, we look forward to a sophisticated case management system where we collect as much data as appropriate so that we can do an effective analysis in terms of how we begin to reform some of the areas within the prosecutorial arena that's necessary. So thank you very much, Kyle. It is now my distinct honor and pleasure to introduce our keynote speaker for this evening, Professor Angela Davis. It would be I don't know, it would be, she has an extensive and very, very, very impressive bio. And I could spend the rest of the evening talking about her remarkable career. But what I'd like to do is just sort of highlight some of her work so that you get a flavor of how distinguished Professor Davis is. Professor Davis is the Distinguished Professor of Law at American University of Washington, D.C. College of Law. She's an expert in criminal law and procedure with a specific focus on prosecutorial power and racism in the criminal justice system. Professor Davis previously served as a director of the D.C. Public Defender Service, where she began as a staff attorney representing indigent juveniles and adults. She also served as the executive director of the National Rainbow Coalition and is a former law clerk to the Honorable Theodore R. Newman, who was the former chief judge of the D.C. Court of Appeal. Professor Davis is the author of a very influential, I might say, and worthwhile book that really deals with the whole area of prosecutorial discretion, entitled Arbitrary Justice, the Power of American Prosecutors. She's also the editor of another fine piece of work entitled Policing the Black Man, Arrest, Prosecution, and Imprisonment. She's the author of many scholarly publications. She also won the American University Scholar Teacher of the Year in 2015. She was also the 2018 recipient of the DC Bar Thurgood Marshall Award and the 2016 recipient of the American Bar Association Rita Trust Award. Professor Davis is a member of the American Law Institute and the Council on Criminal Justice. She is a member of the Board of Trustees of the Frederick Douglass Jordan Scholarship Board and the Board of Directors of the Sentencing Project. Professor Davis was a reporter, I might add, for the ABA Justice Kennedy Commission and a member of the ABA Commission for Effective Criminalization. She also served as a member of the Advisory Board of Vera Institute of Justice, Prosecution, and Racial Justice Program. She teaches criminal law, criminal procedure, criminal justice ethics, prosecution and defense, and criminal defense theory and practice. Professor Davis is a graduate of Harvard Law School and Howard University. It is my distinct pleasure to introduce to all of us Professor Angela Davis.
Thank you so much, Justice Harper, for that introduction. And I also want to thank the Connecticut Bar Association and the Connecticut Bar Foundation for inviting me to be a part of this really important program. I'm honored to be with you this evening. And I'm really grateful to you for focusing on the role of prosecutors and the role of prosecutorial discretion, I should say, in disparate outcomes in criminal cases. This is a topic that I'm really passionate about and that I've been focused on for decades. So I was really delighted to accept your invitation to be part of the program. I'm also really happy to hear about the groundbreaking work that's being done in this state and to congratulate you on that work. Most states, I will tell you, are not collecting data on prosecutorial decisions and making it available to the public. And I cannot tell you how important that work is. So thanks to everyone who's been involved in that work. It's incredibly important. Before I share my thoughts on prosecutorial discretion, I'd like to share some statistics with you about the state of the criminal legal system in our nation as a whole. Mark and Kyle shared with you some really important stats about the state of Connecticut. The rest of the country has similar stats. I believe we're really in a state of crisis in our criminal legal system. We've got about 2 million people in prisons and jails, with about 4 million or so on probation and parole. And we have extraordinary unwarranted racial disparities at every step of the criminal process. Black and brown people are more likely than white people to be arrested. Once arrested, they're more likely to be convicted. Once convicted, they're more likely to face stiffer and longer sentences. African-American men are 6 times more likely to be incarcerated than white men and 2.5 times more likely than Latino men. And if the current trends continue, 1 in every 3 Black men today can expect to go to prison in his lifetime, as can 1 in 6 Latino men, compared to 1 in 17 white men. The racial and ethnic disparities among women, although less substantial, are also very prevalent. So I believe we're in a state of crisis, not just with regard to incarceration, but with unwarranted racial disparities. Black and brown people are treated worse than their similarly situated white counterparts at every step of the process. And that's whether we're talking about people who are charged with crimes or people who are victims of crime. When we're talking about the arrest stage, because of racial profiling, Black and brown people are treated worse. This is also true at the prosecutorial stage, which I'm going to spend most of my time talking about today, as well as sentencing laws that have a disparate effect. And when I say similarly situated, I mean whites who are engaged in the same behavior as African Americans or Latinos are treated better than their Black and brown counterparts. People who have the same criminal records or lack thereof, or who are alleged to have engaged in the same behavior. And with victims who've had the same experiences, Black and brown people are treated worse in our system. Well, why is that? The reasons are really complex, right? There are socioeconomic reasons, the socioeconomic reasons that cause people to find themselves in the criminal legal system. We all know about the connection between poverty and crime, between trauma and crime, between the lack of health care and the lack of education and crime. But there are also discretionary decisions that are made in the criminal legal system that also contribute to these disparities. Discretionary decisions by officials in the criminal legal system. Everybody's familiar with racial profiling, when police officers stop and frisk Black and brown people, but bypass whites who are doing the same things or doing nothing. They create a racial disparity. And when prosecutors charge Black and brown people and don't charge whites who are engaged in the same behavior and have the same criminal record or lack of criminal record, they're also creating a racial disparity, an unwarranted, unfair racial disparity. And I hold prosecutors more responsible than other officials because they are the most powerful officials in our criminal legal system, in my opinion. They, in essence, control the system through their charging and plea bargaining decisions. It's the prosecutor who decides whether an individual is going to be charged and what they're going to be charged with. It is the prosecutor who decides whether a person gets a plea bargain and what that plea bargain is going to be. Prosecutors alone make these decisions, and it's very easy for prosecutors to bring charges against people, right? And the reason is because the standard for bringing charges is really low. It's a standard called probable cause, more probable than not. And that's a much lower standard than the proof beyond a reasonable doubt that prosecutors need to convict a person at the time of trial. And because of that, unfortunately, many prosecutors engage in overcharging. By overcharging, I mean piling on charges simply because they have probable cause, even when they know they can't prove the charges at the time of trial. Even though they know they can't prove it beyond a reasonable doubt, they pile on these charges. Why do they do that? Because it gives them an advantage at the plea bargaining stage of the process. So for example, if I'm a person who's facing 10 counts of, say, distribution of cocaine, and each one of those counts carries a 5-year mandatory minimum, I'm facing 50 years in prison. So the prosecutor offers me a deal and says, I'll let you plead guilty to one count and I'll dismiss the others. Even if I'm innocent, and one count means I end up in jail for 5 years, which is a long time, but it's not 50 years. I might take that deal, even if I'm innocent or even if I have a defense. Why? Because going to trial is risky business. You never know what a jury is going to do. And if I go to trial and that jury convicts me, I'm facing 50 years now if I get convicted of everything, and I'll go to prison for the rest of my life. So I might take that deal, even if I'm innocent, even if I have a strong defense. And this happens in courtrooms across the country every single day. This is what is passing as justice in our courtrooms across the country. Prosecutors control these decisions. Whether you get charged, whether you get a deal, it's totally up to them. They make these decisions behind closed doors, and they are accountable to no one other than their supervisors, the chief prosecutors in that office. They're also accountable, however, to the people, and I'll get to that in a minute. I want to talk about accountability for sure. But when you consider the fact that 95 to 97% of all criminal cases in this country are resolved with a guilty plea, you can see why I say prosecutors control the system. I mean, people think there are all these trials going on. They're watching Law and Order and all these versions of Law and Order on TV and all these TV shows, and they think all these trials are going on. But there's not a lot of trials going on in the United States of America. There are a lot of guilty pleas going on, and prosecutors control that process. So you see why I say that they are the most powerful. Well, do prosecutors help to create and perpetuate racial disparities? I think so. They're not the only ones who do, obviously. There are plenty of reasons I mentioned before, but they contribute as well. I do not think prosecutors do that intentionally. I don't think there are prosecutors sitting at their desk saying, oh, here's a Black person arrested for a distribution of cocaine. Here's a white person. I'm going to go after the Black person and let the white person go. I personally do not believe that that's happening. I think most prosecutors are doing their jobs the best they can and trying to do justice. But they do contribute. It's more complicated than that. And I think there are a lot of reasons. One of the reasons, I think, is something called implicit bias, which I'm sure many of you may have heard of. all of us, me, you, everybody in this country, probably in this world, suffers from implicit bias. That's those unconscious views that we all have, that unconscious views that opinions that we make about other people based on their race, their ethnicity, their skin color, their body size or type, their sexual orientation. It could be anything, but it's totally unconscious, right? We're not even aware that we're judging people. It comes from the influences around us. It's that thing that makes a white woman on an elevator. When a black man gets on the elevator, she pulls her purse tighter and moves to one side. She's not even aware she's doing that, right? Because of implicit bias. And we all suffer from it, no matter our race or ethnicity, right? Black people do too, brown people do too. We all suffer from it. But I was talking about implicit bias, and I was saying that, we all suffer from it, but when you're a person in a position of power and your implicit bias is causing you to make decisions that impact the person's liberty, it becomes a huge problem that needs to be dealt with. So let me give you an example of what I'm talking about. So let's say we have a prosecutor who's got a case in which a young African-American male, I'll call him Jamal, has been arrested for distribution of cocaine. His overworked public defender comes to the prosecutor and says, listen, Jamal doesn't have any prior convictions. He actually has a drug problem, and he was actually selling drugs to feed his drug habit. He's dropped out of school. He doesn't have many opportunities. He really needs a good drug program to turn his life around. Can you give him a chance? And the prosecutor looks at the attorney and says, well, I'm sure he does, but I don't have any drug programs. Does he have a drug program? Can you get one? The public defender doesn't have one. Jamal's parents can't afford it. So the prosecutor goes forward with the charges and charges him, and he's convicted. Another case might come before that same prosecutor, right? Todd, let's call him Todd, a white kid is caught selling drugs at his high school. And he comes in with his well-paid private lawyer, private practice, and maybe somebody even worked in the prosecutor's office in the past, as oftentimes white-collar private defense attorneys do, might know people in that office. The lawyer comes in and says to the prosecutor, listen, please drop these charges against Todd. Todd is an excellent student. He's been accepted to college. He's got a great future ahead of him. He's a good kid. He has no prior record, but he has a drug problem. And he was just really selling to feed his drug habit. And his parents have found a great residential drug program for him. Well, he'll be in residence for 6 to 8 weeks, residential, not out in the community. If he completes that program, would you consider dropping the charges against him so he can go forward with his bright future? Please don't ruin his life. Prosecutor looks at Todd and he's thinking, wow, I used to do a few drugs myself when I was in high school, and somebody gave me a second chance, and I don't want to ruin this kid's life. He's got a future. He's got empathy for Todd. And so he says, okay, if Todd can complete the program, I'll dismiss the case. So he gives Todd a break. He says, I'll dismiss the case. I'll even expunge his record. We'll even work on expunging his record so it won't ruin his life. So is that wrong? I don't think it's wrong for him to give Todd a break. He deserves a break, but Jamal deserved a break too. Would I call this prosecutor racist? No, I would not. But his unconscious views caused him to make a decision which created an unfair and unwarranted racial disparity. That's just implicit bias. It's even more complicated than that, though. And it goes to some of the issues that Kyle talked about in his presentation, right? Because there are legitimate factors that prosecutors take into account when making charging and dismissing and plea bargaining decisions. Legitimate factors that they consider that have a racial impact. The American Bar Association has something called criminal justice standards for the prosecution function. And these are like guidelines that the American Bar Association believes that prosecutors should follow, and they're making important decisions about charging and plea bargaining. And they list a number of factors that prosecutors should take into account in deciding whether to charge, whether to dismiss a case. Factors like, for example, the strength of the case. And Kyle talked about this in his presentation. How do we determine the strength of the case? But that's a factor that the American Bar Association says prosecutors should consider, and it makes sense, right? So if you've got a weak case, you don't want to go forward with a weak case and waste resources and put the victim through it, put the defendant through it when you know you can't win the case. That's something you want to take into account. But how does a prosecutor determine the strength of the case? Well, one thing they take into account, one factor they consider is the witness. Do I have a good witness who can convince the jury of the person's guilt? So if I have a case with a victim who's articulate and well-spoken and tells a good story and is going to be convincing, then I might think I have a strong case and I may go forward. So just to give you an example, let's say I'm a prosecutor and I've got a case where a lawyer, a white lawyer, so we can talk about racial disparities. A white lawyer is robbed of her briefcase out on a street. And I send her a note and someone's arrested. I send her a notice. I'm the prosecutor. I send her a notice to come to my office for a witness conference. She shows up on time. We have a great talk. We go over her testimony. She's articulate. She's well-dressed. She speaks the Queen's English. And I'm thinking, wow, this is a really good witness. She's going to be very convincing on the witness stand. I'm going forward with this trial. The defendant's not going to get a plea in this case. So I go forward with that case. I get a conviction. That defendant goes away, no plea bargain. But maybe there's another witness that comes through, Black woman. Let's say her apartment's burglarized and the burglar takes some cash or TVs, some stereo equipment. They arrest someone. And I send a notice to her too to come to my office for the witness conference. She shows up. She's not quite as well dressed as the lawyer. She's not well dressed at all. She's not very articulate. She doesn't communicate that well. She doesn't tell, not as educated. She doesn't tell her story as well. And the prosecutors think, she doesn't make a very good witness. I don't know if the jury is going to really find her convincing. I have a weak case. This case isn't very strong. So I'm going to offer this defendant a plea bargain. And, and I do, right? That defendant gets a break, right? Or it could be another scenario where the Black woman who's poor and who doesn't have the resources or education, maybe she doesn't show up for the witness conference at all, because maybe she does day work, the kind where if you don't show up for work, you lose your job. So she doesn't show up. Or maybe she doesn't show up because she's not that comfortable coming to the prosecutor's office, because that's the same office that prosecuted her son, and she's just not comfortable coming. So she doesn't show up. And the prosecutor thinks, well, she's not interested in prosecution, so I'm just going to give this defendant a plea or even dismiss the case. And guess what? That's another factor that the ABA says prosecutors should take into account, the interest of the victim in prosecution, right? It makes sense. Like, victims don't determine the outcome, but prosecutors can and should take into account the victim's wants and desires when making a decision about charging. And the ABA says that they should do that. But you can see it can have a racial impact. These are all legitimate factors, but they can have a racial impact. Not because the prosecutors being racist or trying to treat Black victims or defendants different from whites. It's not even in their consciousness, but they're causing these disparities. And you know what? I don't give prosecutors a break just because it's not their fault. I don't give them a break because if they're aware that they're causing this harm, they have a responsibility to fix it. They have all that power and discretion, and they can change their practices to fix the problems with that power and discretion. So there's a Bible verse that I like a lot. And it goes something like this: to whom much is given, much is required. And that's the prosecutor. They're given all this power and they're required to use it to do justice. In fact, the United States Supreme Court says just that in a case called Berger versus United States, in which the Supreme Court says, and I'm paraphrasing, but basically they say it's not the duty of the prosecutor to seek convictions. It's the duty of the prosecutor to seek justice. And what does doing justice mean? Sometimes doing justice means seeking a conviction, but sometimes doing justice means dismissing a charge or not bringing the case at all. The prosecutor represents the entire community, right? The entire community that includes the victim, it includes all of us in the community, but it also includes the defendant. The defendant is part of the community too. And so the prosecutor must do justice for all. It's a hard job, but that is the duty of the prosecutor. And I do believe prosecutors have the responsibility to use that power to try to reduce the prison and jail population and to end these awful racial disparities. And so I want to say a little bit before I close about accountability, which I mentioned earlier. I talked a lot about the responsibility of prosecutors, but I want to talk a little bit about accountability. You know, we need to hold prosecutors accountable. It was mentioned earlier, I think it was Mark who mentioned the fact that, you know, in most jurisdictions, prosecutors are elected officials. I think in all but 4 jurisdictions. And Connecticut is one jurisdiction where they're not elected. But there is a process here for the public to weigh in, and they have an opportunity to weigh in on the appointment of the chief prosecutor. And I understand that in Connecticut, the public has been more involved in that process in recent years, and that's a good thing. I'm happy also to say that there is a movement in this country, a small but growing movement of what I call reform-minded progressive prosecutors. These are people who ran for office ran for district attorney on the platform of reducing the prison and jail population, ending racial disparities, and they are winning, and they are in these positions. Larry Krasner in Philadelphia, Kim Fox in Cook County, Kim Gardner in St. Louis, George Gascon in Los Angeles, many, many others. And they ran for office saying to the public, I'm going to do everything in my power and discretion, consistent with public safety, to reduce the prison and jail population. I'm going to oppose cash bail. I'm going to set up meaningful wrongful conviction units. I'm going to set up sentencing review units where I go back and look at whether people are serving too much time and fight to get them out. I'm not going to charge juveniles as adults, and I'm going to take affirmative steps to try to reduce racial disparities in my jurisdiction. I think this movement of reform-minded prosecutors is important. I hope it will grow, because every prosecutor has the responsibility to do justice. And one of the most important things a prosecutor can do in achieving that goal is to use her power and discretion to reduce the prison and jail population and to end racial disparities in our criminal legal system. Thank you.
Thank you so much, Professor, for a wonderful presentation. You talked about a couple concepts that are very dear and close to my heart, and that is the concept of implicit bias. Certainly, it exists within the criminal justice system. It exists within our society, and I think we need to focus a little more on that, because your point is well taken in terms of the decisions that are made by prosecutors. All too often, they're unaware of the effect of the decision, and that those decisions can result in disparity. The other issue that is there and close to my heart is the whole issue of accountability, and that is certainly something I want to discuss with our panel. And the third point you made, which is another topic that I'm interested in, is the need for more progressive prosecutors. Reform is absolutely essential. And I dare say that there are ways that prosecutors can perform their responsibility and contribute to a declining in the number of people who end up in prison, because they do have a wide, actually unchecked discretion. And if that's used in an appropriate way, they can do their job and they can do justice. And I'll talk about that with the panel, because I think that prosecutors should serve as ministers of justice and not seek to achieve a conviction, although convictions and incarceration in some cases is justice. And so we need to focus on that. So I really enjoyed your presentation. It was illuminating, and I think you touched upon all the salient points that need to be explored in detail by prosecutors, not just in Connecticut, but throughout the country. So thank you so much for agreeing to participate in this discussion, and thank you so much for a wonderful presentation.
Thank you.
All right. Now I'd like to move to our panel, and I think what we'll do, we have 4 members. They are Diane Gordon-Lyde and our Chief Public Defender, Deshawn Bolden Lewis, who I might say tried her first jury trial before me years ago. We won't talk about the number of years, but that's a fact. And another individual that I'm very proud of, that's the Chief State Attorney, Patrick Griffin. And I say that because I'm well aware of Attorney Griffin's dedication to reform. And I expect to see more reform under his tutelage coming out of prosecutorial offices around the state. So what I would like to do is have each panelist sort of introduce themselves. I'll give you 5 minutes to talk about yourself. And then after that, we're going to engage in some discussion. And you already know I'm going to ask you about implicit bias. I'm going to ask you about accountability. I'm going to ask you about whether you think that prosecutors are the most powerful official in the criminal justice system. I think they are. We're going to talk about that, and we're going to talk about a whole lot of other things. So why don't we start with Mr. Eng?
Hi, good afternoon. I want to say thank you to everyone for actually having this important discussion. My name is Tahiba Bain. I am the founder and executive director of Women Against Mass Incarceration. I'm also the first inaugural Grade 8 inductee here in Connecticut of the Hall of Change. I run a nonprofit organization that help advocate for formerly incarcerated and incarcerated women and girls. We do community engagement, we do policy work sometimes, and we also we work with ACLU. We were actually one of the people that helped with the Senate bill for transparency and criminal justice for the prosecutors. And I'm just grateful to be here and to be amongst all of you wonderful people.
Certainly.
Thank you.
Okay. Tashawn Bowden-Lewis.
Good evening, everyone. It is a delight for me to be able to be here, to be part of this illustrious panel, as well as to be a part of this program that's being sponsored. We all know that Justice Baker Motley was phenomenal on many levels. The legacy speaks for itself. I am the Chief Public Defender for the state of Connecticut, and I am honored to be in that position. I was recently appointed, officially, I would say, I guess in July 1 of this year. And but I've been a public defender my entire career. I've been practicing for 25 years. I started out in the New Haven lower courts, the GA, then progressed to the Waterbury higher court, the JD, became the public defender for that, the acting public defender for that district. And then ultimately became the public defender for the entire district, and now I'm the chief public defender. So again, it's really wonderful to be a part of this panel and to talk about discretion, prosecutorial discretion, the outcomes, and the other things that are important in regards to our system. So I'm excited to be a part, and I welcome the questions, Justice Harper.
Thank you, Tasha. Chief State's Attorney Patrick Griffin.
Thank you, Your Honor. It's a pleasure to be here tonight. I want to thank the Connecticut Bar Association for inviting me. I was appointed Connecticut's 9th Chief State's Attorney in May, so Tashawn and I were appointed a few weeks apart. Like Tashawn, I came up through the ranks. I spent approximately 16 years of my career in Waterbury, 9 years or so in the low court, and then a number of years in Part A, trying Part A cases. In 2011, I transferred here to the Office of the Chief State's Attorney to take up duties running the cold case and shooting task force, which investigated unsolved homicides across the state. In 2016, I was appointed State's Attorney in New Haven. I held that position until May when I was appointed as the Chief State's Attorney. Like Tashawn, I'm eager to answer your questions. I think the topic is both timely and important, and I'm ready to answer the questions for you, Justice Harper.
Okay, thank you, Attorney Griffin. Let me just say this. I tend to think that the prosecutor is the most powerful official in the criminal justice system. And I think that their decisions control the directions and outcome of criminal cases. And I also tend to think that their decisions are totally, practically, their discretionary systems are practically or virtually unreviewable. Do you agree with that? If not, why not? If so, do you think that we need to talk more about accountability, implicit bias, and how that impacts the decisions that prosecutors make? I open that up to the panel.
I guess I'll start. Again, hello, good evening. I'm Tashawn Bowden-Lewis, and I believe that the prosecutor is one of the most powerful components in our system. And the reason why I believe that is because it's a twofold thing. I do agree with Professor Davis the prosecutor has that power to charge, and that's exclusively within their purview. When we're in negotiations, obviously a judge is able to come in and help either up or down with actual sentencings, offers of that kind of nature, but the actual charge is going to be put down for a client is all within the power of the prosecutor, and that's huge. But also, the other part of that is the prosecutorial discretion, because a prosecutor is able to say no, yes, or maybe, and that's huge. So those twofold things right there make that the prosecutor one of the most powerful components in our system. And the fact that discretion is a double-edged sword, right? Because when discretion, it can be used to be able to see weaknesses and let them go. But it also could be used as a tool for to mask things like microaggressions and implicit bias. Those things do exist on all levels, obviously, but when it comes to a prosecutor, for some, that can be used in a way that reflects what the data has been shown. Even though it was mentioned earlier that the data is limited and needs to have more information for it, the numbers speak for themselves. Black and brown people are overrepresented. So accountability does need to be taken into consideration as well too, because there really is not much of a check and balance there. But I do believe that collaboration with the prosecutor's office is important. It's an adversarial process, obviously, for us, but that things can be worked out. Thank you.
Thank you. Attorney Griffin?
Well, clearly, Your Honor, I do believe that the prosecutor is the most, or certainly one of the most important and powerful actors in the criminal justice field. And prosecutorial discretion at various levels is critical. So we're focusing on the charging decision, and obviously that charging decision does rest with the prosecutor. In Connecticut, 90% of the cases that appear on the dockets will be on-site arrest. So the initial charging decision is made by the police, but it's the prosecutor's duty, both professionally and ethically, to review those charges to determine whether or not those charges are appropriate, whether the charges should be subbed up or subbed down. Is it unchecked discretion? Well, I guess the charging decision is solely vested within the prosecutorial authority. But that's only the beginning of the process. What I think is unique in Connecticut is that certainly for our Part A cases, for our most serious cases, virtually every time the case is on the docket, that case would go before a superior court judge in a supervised pretrial. So there are some checks and balances on the prosecutorial discretion that allows a court to put subtle or not so subtle pressure on a prosecutor to either alter a charge or to seek to reduce a number on a plea.
What do we do about individuals? I'm sorry, Ms. Bowden, you wish to, Tifa, do you wish to comment? Ms. Bain, I'm sorry, you wish to comment? So I get excited, but, you know, you gotta, I mean, this is.
Thank you, Your Honor. Yeah, well, I agree with Sean, Ms. Lewis, as well as with Mr. Griffin, because the prosecutor is, I believe, the sole authority. I mean, I know the judge have the ultimate say, you know, but the judge, we all know the judge looks to the prosecutor, looks to the state for their recommendation. And with the prosecution, you're right, Mr. Griffin, that the onslaught is the arrest charge is from the police department. However, the police officer he can put down as many charges as he likes, and it is up to the discretion of the prosecutor to remove and or stay with the charges that was put on that person. And because overworked and just like the fast pace of the courts, usually 9 times out of 10, the charges that are put on the arrest warrant are usually the ones that stays, and it doesn't necessarily fit the crime, but now we have to rebuild this case or build a case against this person that suits all the charges that have been put on that case.
What do we do about individuals who are similarly situated, not the same, but individuals who are charged, say, in one district with burglary, in another district with burglary? They have similar background. One's white, one's black, and they're treated differently based on the prosecutor's plea bargaining or discussion with defense attorney. Should we expect uniformity when individuals are similarly situated in terms of how those cases are handled, in terms of the charge, or in terms of plea bargaining, et cetera? Since in Connecticut, we have prosecutors have total discretion in terms of the charge they might want to bring in one district and in another district. And so you might have similar situated cases being handled differently in each jurisdiction. Is there something we need to do about that? Do we need uniformity? How does the panel just feel about that issue? How do we
May I address that?
Sure, certainly, please.
So certainly, I think we recognize that there is disparate outcomes in the 13 judicial districts. So the question is to whether or not we want uniformity. I think that the answer is we want consistency, but not rigid conformity, or because not every case is the same. An individual charged with an assault second in Bridgeport and an individual charged with an assault second in Waterbury, while charged with the same offense, there are many factors that would go into a potential disposition. But in terms of trying to address disparities across the board, I might add that, when I took office in May of 2022, the division, like many state agencies, is in a period of transition. We had lost 20% of our staff. And with the loss of that staff has given us some opportunities to hire, to bring in some new folks, new ideas and new enthusiasms. And one of the things that we're working on, Your Honor, is Connecticut's first prosecutorial standards. Currently, there are no prosecutorial standards, written prosecutorial standards for the prosecutors in the 13 judicial districts. We're working now to put together Connecticut's first standards. We're seeking to synthesize the best practices that are outlined in the National District Attorneys Association professional standards, the American Bar Association professional standards, and the federal prosecutorial standards, in order to come up with what I think will be the blueprint for the Division of Criminal Justice. Once those standards are in place, I think it will become easier to train our prosecutors, and we have so many new ones that this is really the right time to train our prosecutors in a more consistent manner across the board. I don't know whether it's ever going to be possible to remove all disparities, but I do think that the Division of Criminal Justice must do a better job at training and at focusing on creating consistent policies across the 13 JDs.
Well, in terms of plea bargaining, as you know, certainly we all know that plea bargaining is sealed from the public. Is that good or bad? Is that something we need to consider, something we need to look at? The public has no idea as to why a prosecutor might charge one individual, whatever, and why he might negotiate a plea with another individual. And there might be reasons, justifiable reasons, but the public doesn't know that. What they see is someone who has sort of the same charges, one receiving one deal, the other not, and being forced to go to trial. How do we cause for the public to become more educated about the function and responsibility of the prosecutor? And should plea bargaining remain sealed from the public? And I just throw that out to the panel for discussion.
I believe that plea bargaining should be shielded only because confidentiality. There are certain things that everyone does not need to know in regards to a client and what's going on with that client. The background, the backstory is very important. And as defense attorneys, mitigation is what we're bringing forward. We're bringing forward the backstories because every person needs to be seen as an individual when we are talking in negotiations with the judge and the prosecutor. And so kind of going back to one thing you said, Justice Harper, about the similarly situated people, it should be a case-by-case analysis. I mean, yes, on paper, something may seem the same, but it is also about the backstory and not just about the race or gender or class of the client that should be looked at. But anyway, getting back to your question for the situation in terms of what we can do in regards to this aspect of things. When Pat mentioned about hiring in a diverse manner, diversity is very, very important. Not only for what we do as defense attorneys, public defenders, but also for the prosecutors. So if there are people who also look like those who are being brought forward in these situations, that helps a lot as well too. But training on diversity, training on microaggressions, training on a confirmatory bias and implicit bias is very, very important as well too. It's about a culture shift to educate so that the prism of knowledge that everyone goes into that court, the chambers with, is wide enough to catch what everybody is saying and not just one individual.
Ms. Van, you'd like to comment?
Yes, I just want to make sure that Justice Harper, that your question it's a twofold question about should plea bargains be sealed?
Should the public,
and
should the public be aware of what goes on with respect to plea bargaining? Should there factors that should be disclosed? Public have no idea what's going on. They see two people charged with the same charge. One gets one deal, the other gets another deal. The question is why? What's going on? I mean, does that require us to do a better job in terms of educating the public, or should there be some other factors that we take into consideration when we engage in plea bargaining?
Well, when you're engaging in plea bargaining, that is between the prosecutor and the defense attorney and the client, right? And there are factors, and I think that people should be made aware because I believe Professor Davis made a very valid point. Like, there's two cases basically, and because of a person's color and or race, their outcome is a little more daunting and a little more heavier than a person that is white that comes in and have an attorney that's able to advocate for them. When you have a plea bargain, most people are taking plea bargains out of sheer fear, right? Most people they don't want to go to prison, but they say, well, I'm gonna take the lesser role, the higher role or the lower role, because if I'm getting presented with take it to trial and go to and get the top amount of time that I can possibly get, or plead this out and get a lower sentence, then yes, I'm going to take the plea. I think the public should be made aware to some extent. I don't think it should be kept as between us and them, because they need to know. The process between the public needs to weigh in. She's an attorney, but Professor Davis did make a point to say that the process in Connecticut is the public have a little weigh in today to appoint the chief prosecutor. I think we need to let the public be aware of the things that they can do to get involved, because a lot of times public does not know. As far as what we know is that we get kicked out of courtroom. We need to do more court watching. We need to do more participatory defense, because that's something that I do in my organization. And when the prosecutor know that someone's in that courtroom watching them and watching their behavior and seeing the outcome of the cases that come before them and shows the disparities, they tend to have a different shift. So I think that we need to welcome the training of court watching and participatory defense. And that's how the public can be made aware of how things are run. Because we all know, and I'm a formerly incarcerated woman, and we all know that the prosecutors have the discretion to say to make or break us, to send us to prison or not. And when the public can sit in that courtroom and listen and hear and understand and get educated, civically educated about what happens and what the law means and how and what it stands for that individual, that prosecution and that judge in that court itself has a different take on what happens to an individual. I've seen it happen personally.
Thank you. How do we go about informing the public? Whose responsibility should it be? What format, if any, should it take? I mean, how do we go about informing the public about how the system operates, specifically with respect to not only charging decisions, but plea bargaining decisions? How do we do that? How do we inform the public? If we think the
Well,
public,
I think,
I'm sorry, go ahead.
no, I apologize. I'm sorry.
No,
for
no,
cutting
no,
you off,
no,
Justice
no,
Harper.
no,
I
no
believe
problem.
what we started in Connecticut, like what the Prosecutorial Accountability and Transparency Bill is doing is really great, and it informs in such a manner. But I think that, you know, in respect to Attorney Lewis, Golden Lewis, what she said is that that's private. A lot of times you have difficulties. The defendant have a lot of things that does not need to be disclosed. So how we should do that is very carefully and on a case by case basis. And then we can get permission to say, if you do not mind, would you mind us disclosing or having this, you know, put to the public, and let the public in on the processes of how plea bargaining is made.
Just to add
A lot of people don't know. I'm sorry.
Tashawn?
I'm sorry, I cut you off, Ms. Bain. But just to
No,
add
that's
what you're saying, though, a direct vehicle obviously is the defense attorney, right? The public defender, the defense attorney, the private bar. That person who's the advocate for the client who's being represented is going to be the first line to tell the client what is going on, what happened in pre-trial negotiations, what's discussed, what was the outcome, and how this is going to affect him, her, or they, and what's going to happen next. So as long as we're doing our part in terms of that portion of it, then it can flow from there naturally, from the clients to the client's families and whomever else the client may choose to, speak to. But that first line is going to be their advocate, which is their attorney.
If I may, I agree with,
certainly.
Sorry, Your Honor. If I may, I agree with Tashawn. Putting my prosecutorial hat on, I've always believed that if I say something in chambers, I would be prepared to say it on the record. However, from a defense point of view, there have been many pretrials that I have been part of where issues have been raised that would not be admissible in court, would be prejudicial to the defendant, but are relevant considerations for the judge to be aware of. And so if a position is taken that everything that is said in pretrial is then said on public, my concern, perhaps I'm speaking out of school because I'm not a defense attorney, but my concern might be that it would chill the value of the pretrial discussions. Because those pretrial discussions, as you know, Your Honor, are very in-depth at times, are very and can be and should be dispositive. I mean, you have to put on the table everything you need to put on the table, and many of the things are simply not admissible in a court of trial, meaning that they would not come before a jury, but they might factor in regards to the leniency, mitigation, mercy, and things along those lines.
Thank you. Let me ask you this. I think the data clearly suggests that there's disparity at every stage of our criminal justice system. What can we do to reduce, if not eliminate, disparity? What can we do? And I'm talking about all aspects of the system in terms of the police officer who makes the initial arrest, because as you know, police officers have a lot of discretion, especially when it comes to offenses like traffic stops, for instance. And so my concern is I'd like for the panel to at least talk a little bit about, from their perspective, what we can do to reduce, if not eliminate, disparity in our system.
If I might, one of the things that the division is focusing on in terms of our training is a topic that frankly 5 years ago would not have been discussed by prosecutors, and that's identifying implicit bias, coming up with strategies to try to combat implicit bias. So in December, let me just back up, with the number of folks that have retired, as I've indicated, we have many openings across the state. Since July, we've hired 14 prosecutors over 3 commission meetings. And in December, we're going to begin a 5-day boot camp, we call it. It's actually a curriculum for new prosecutors. And we spend out of the 30 hours, it's actually 6 days, I'm sorry, out of the 30 hours, we spend now 5 full hours on procedural justice and managing unconscious bias. I think it's important that prosecutors begin to talk about this, to recognize that as human beings, we all have bias. But it's not just, okay, so we acknowledge we have a bias. Now we have to come up with strategies to try to combat that bias. And I think that's crucial. I think that training is one of the most essential elements in combating disparate outcomes. Consistent training across the board for not only new prosecutors, but for existing prosecutors.
Anyone else wish to?
Yeah.
Certainly.
I do echo, as I said earlier, the whole concept and the whole idea of educating and training, and that's #1 top priority. But I also believe it's important as well too for prosecutors to be empowered by supervisors and whomever else to really be more progressive in terms of what they are going to do with their discretion. A perfect example would be during the height of COVID. I was in the field during that time, and the amount of cases that were disposed of in favorable ways, that should have been the process years ago. But because we were in a pandemic and, there were a lot of people that were incarcerated and it needed to try to move things out, a lot more prosecutors were empowered to be able to really look at cases and say, you know what, we're going to drop this case, or you know what, this person really should be able to get out or get a promise to appear for whatever may be going on. So empowering more to be progressive and to be more in tune with what's really happening is going to help to slash more of those disparities for Black and brown people.
Ms. Bain, you wish to comment?
Yes, thank you.
You're welcome.
I'm going to echo, right? Implicit bias is the subconscious bias that's created by nature, nurture, and experience. It just happens, right? And that's what I believe. And in order for us to reduce and eliminate the disparities, we have to first acknowledge that we have these biases and know that it comes straight and face the fact that racism and racial disparity is a #1 factor in our implicit biases, regardless of whether we want to admit that or not. And once the prosecutor, and I'm not saying it's intentional, it's just what it is. And we need to understand that education and training is good. It's great, and everyone needs it, absolutely. But we need to also come together and be accountable for who we are as a people and as a person. And once we become accountable and understand and stand in face factor of that we do have these biases and that we do operate in them, and sometimes because it's like sometimes you could be in a courtroom and the prosecutor can have a bad day. And if he or she's having a bad day, guess what? That person that's standing there is going to get the brunt of his or her bad day. And we don't know that. We're not saying that that's, they're not intentionally doing it, but because of what's going on within themselves, they're going to throw the hammer at people. And we need to be honest with that. So you ask, how can we reduce or eliminate the disparities? First, we got to be honest with ourselves that this is a problem. The implicit biases comes from a racial bias. And once we really set foot into that, and whether people want to admit that or not, that's when we can eliminate and or reduce. I don't know if we can ever eliminate the disparities, but I definitely know we can reduce it. But we need to reduce it by first becoming accountable with ourselves and owning up the fact that these implicit biases are governed by the nature, the nurture, and experiences of who we all are. And that's my opinion.
Yeah, no, that's very interesting. I mean, so the issue of implicit bias, before we hire, say, prosecutors, should that be explored in terms of the vetting process?
I believe it should be. I believe it should be because, we do a great as far as like implementing diversity these days. I mean, it took us a long time to get here, but we're here. And I think it's great, but we also and it's not just for, people that's not of color, it's for all people. And yes, we should vet them. We should ask them these questions. We should have social workers working alongside these people, and the social workers should be a part of their training, going through some type of evaluation, asking them about certain questions that they ask people that's in prison, you know, to get an evaluation or an assessment of who they really are. And that right there will help you in the vetting and training and education process. That's my belief.
Anyone else wish to comment on that? It has been said that some prosecutors are interested in conviction, that the aim is conviction. And I've always said that prosecutors should serve as ministers of justice. You bring in a case, police officers arrest somebody based on probable cause, which is a lower standard. What do you do with that? If you investigate and it's fairly clear that you do not have enough evidence to convict beyond a reasonable doubt at the trial, should you use that arrest, that probable cause, as a hammer or a wedge to cause for someone to plead? Or should a prosecutor say, look, I just don't have enough here and nolly the case? What do we do with that? Should a prosecutor only go for it if they know, or at least feel, because you never know, that they have enough evidence to convict someone using the standard of proof beyond a reasonable doubt? Or should they proceed to trial when all they have is PC and do not have good witnesses or sufficient evidence to prove the case beyond a reasonable doubt? And thus, as was indicated, a lot of individuals, as we know, are fearful of a trial because you never know what's going to happen. And so a lot of folks plead out because they don't want to risk what might happen at a trial. Why do we handle that? Probable cause versus proof beyond a reasonable doubt, the decision-making process, what should be taken into consideration? Should you nolly a case if you don't have sufficient evidence? So should you outright dismiss the case? What you're thinking about those two concepts and how they play into the decision of whether to go to trial or not?
So, Judge, from my point of view, obviously, probable cause is the minimal standard in order to effect an arrest. But a good prosecutor, in order to maintain a prosecution, should believe in good faith that he or she could develop enough evidence to convince a jury beyond a reasonable doubt. That standard is fluid because what if you have witnesses that are missing and if you do have them, you don't have them today, but if you do have them for trial, then you do believe you can ultimately carry the state's burden of proof beyond a reasonable doubt. I think if it becomes clear to a prosecutor that he or she cannot maintain that burden, that it is incumbent upon the prosecutor to enter a nolly. I think looking at the stats from last year, 59% of the cases that came in were nollied by prosecutors. I'm confident that our prosecutors across the board in the division are taking appropriate steps to evaluate cases. But you know, the initial probable cause determination is made, 90% of the cases are on site, so they're made by the police. And 10% or so, and you correct me if you think I'm wrong on that, if it's the numbers, you know, I would say 10% are by warrant, and there the prosecutors are more involved because statutorily we're required to sign those warrants. But clearly, we should not be pursuing a prosecution if all we have is probable cause. The question is, at what point should we terminate the prosecution?
Anyone wish to, Sean, Ms. Bowden, wish to pick up on that topic?
Definitely. Yes, the prosecutor has to look at each case and assess the case at its face value. Look at what it is. And again, use your discretion. That's what you have it there for. It is not rocket science for a lot of situations here. The prosecutor has that power right there. And you know, discretion does not always have to mean conviction, doesn't have to mean a punishment that involves incarceration. And I think that a lot of times too, that there is a fear of dismissal, which it shouldn't be. But again, assessing it case by case, seeing what you have, really listening to the defense attorney, the public defender, who is really trying to show who this person is, the human person who this is, and what you may or may not really have. If we're really being fair about it, this is about fairness from the eyes of the client or defendant, the alleged victim, fairness from the prosecutor side as well as the defense side. We should be able to come up with a solution or a resolution that is reasonable. So assessing it and just taking it at face value, So sometimes, yes, immediately dropping the case, completely dropping the case is what is important and needed. It sets a precedent that shows that the prosecutor is dealing with what they really have and is being a true minister of justice.
All right, thank you. Ms. Bang? Okay. Let me,
I concur.
okay, okay, fair enough. Let me ask you.
Yeah, that's right.
Okay, all right, fair enough. Not that we have a lot of this in Connecticut, but what do we do if we have a isolated case where a prosecutor engages in misconduct during the plea bargaining negotiations, for instance, using pressure tactics to try to get someone to plead? What do we do? How do we handle that if it happens? What should be the appropriate response for something like that?
I'll take that, Judge. I think if somebody sees something improper, they need to say something. So that means if a judge in pretrial believes that a prosecutor is engaging in tactics that are improper, the judge has a responsibility to alert the state's attorney immediately. If a public defender or a private attorney believes that there is conduct that is improper, it should be immediately referred to the state's attorney to take remedial action, which could include referral to the bar and grievance committee. There's no room for misconduct in, if we are to be referred to as ministers of justice, we've got to live up to that title. So, but people have to say it. Too often, we hear rumors of misconduct. We hear innuendos of misconduct, but people have not stepped forward to actually make a complaint.
Also, to add to that, yes, I agree. Clearly, well, a lot of times the defense attorneys, the public defenders, private defense attorneys are saying they're making the cases, but yet the judge who's at that line of defense right there often does not always go along with what is being said. And so when misconduct is pointed out, just like, for instance, for the Batson challenge, the whole race neutral concept, right? That is so broad that is very difficult for it to even be proven or shown. When things are made plain, the judge, whomever that person may be, has to have enough, no fear, and be able to move forward and say, this is improper and we're not going to allow this, and have that stop right then and there. Because being able to litigate race, being able to say what's going on, to say that this was done in the wrong way, that does show everyone, the public as well as the client, and all sides, the prosecutor's side as well as the defense side, that we're not going to tolerate anything that is unjust.
Professor Davis, as far as I'm concerned, you're on the panel too. And we talked about a number of topics, many of them which you touched upon during your presentation. Would you like to, and I would welcome your response to any of the topics that the panel has discussed thus far.
Sure. Thank you, Justice Harper. This has been a really interesting conversation. I really appreciate the comments of all of the panelists, just excellent comments. I've gained a lot from it. And you're a great moderation. You're asking all the right questions as far as I'm concerned. The one thing you asked about is, that I thought was interesting is like, how much should the public know about the plea bargaining process? And I would ask it even broader, like how much should the public know about what's going on in the prosecutor's office in general? And I think it's an interesting question. For one thing, there are privacy, concerns and confidentiality concerns. Of course, as Ms. Bowden-Lewis pointed out, information about the client, that individual clients, doesn't need to be given to the public. And similarly with the victim, the prosecutor has an interest in protecting the privacy of the victim. But what prosecutors can do is share their general policies about how they make those decisions. A prosecutor can explain the process and say, here are the factors. And I was glad to hear you, Mr. Griffin, talk about you all coming up with these standards for your office, because you can certainly share those with the public and say, here are the things, here's how we make these decisions. Here are the factors we take into account. You can certainly generally talk about that and have the public weigh in, because, they have a right. Again, they don't get to vote for you in Connecticut, but they certainly can weigh in terms of your accountability. So letting them know what you're doing. the public should be able to ask you questions. What are you doing about these racial disparities? And you should be able to answer those questions, generally speaking. So there's a way to share information about how you make decisions and what you're doing while protecting the privacy rights of both the defendant and the victim.
Thank you so much. Do prosecutors have too much discretion? Yes or no? Should it be expanded? Should it be reduced? If so, how? What's the response?
I'll go with that first. I don't think they have too much discretion. I think that it has to be used wisely. That's what it comes down to for me.
How do we make sure that happens?
Well, again, Justice Harper, it goes back to the supervisors empowering their people to be progressive in trying and really assessing these cases and letting these cases go that don't need to be in the system. As well as, again, you have to hammer in the training and the education and diversifying the prosecutor's office as well. Having people who are more diverse is going to be very crucial as well, because it brings another perspective to the office and to the culture of the office when you do that as well too.
I do believe that the prosecutors have too much discretion. I think the discretion should be reduced, and if not reduced, they should be monitored even more. I like what Professor Davis said when she said general policies on the processes that happens within that office. If they if they know that they're being monitored and they have someone that oversees them, it's like an oversight committee, then I think the processes of the public attorney's office, the district attorney's, the attorney's office, the prosecutor's office would be a little less likely to convict on a lot of cases, and a little more lenient and have more knowledge and have more dismissals, because again, it's at the discretion. And like Attorney Bowden said, it is what it is. Look at the case, and if it's not that if it's not that big of a case, or if it's not that big of a deal, and you don't have enough evidence, do what's right. You have the discretion to do it. And if they're being watched, then I think they'll make the right decisions these days. And put in more diverse prosecutors. We need that.
Do we need more I'm going to pick up on that. Do we need more Black and brown prosecutors? If so, why? What are the barriers to recruiting and hiring them?
Yes. To answer your question, yes. And the reason being is because, as I said, that when you have prosecutors who are culturally diverse, ethnically diverse, that brings a whole different perspective and shift in the office. So that when you have conversations, we all have those conversations in our offices about what's going on, cases, what's happening in different terms of when you have your perspective on when you evaluate a case. And then, having another person to say, you know what, maybe you should look at it this way is important.
Justice Harper, since you empowered me to speak on this panel,
yes, I want to hear from you. I want you to bring it.
I agree with Ms. Bowden-Lewis. Yes, we do. But I want to say this caveat: every Black and brown face is not out here trying to do the right thing, right? But I won't name names, but there are some chief prosecutors across this country who are African American, who are locking up more Black people left and right and doing the death penalty than some white ones. So it has to be not just, you have to bring that perspective. You have to care about getting rid of the racial disparities in the system. And yes, the perspective that Black and brown prosecutors bring culturally is so important, but not all of them bring that perspective. And so I'll just add that caveat.
Agreed.
Agreed. I would agree with that. I would agree with that also. Anyone else like to speak?
Yeah, Your Honor, from my point of view, of course, we want to encourage Black and brown attorneys to feel welcome in the Division of Criminal Justice. But to echo some of the points that have been made, first and foremost, we want good prosecutors. We are at an unprecedented time in Connecticut history in which we have so many open positions. And I want attorneys of whatever ethnicity to feel that public service and working with the prosecutor's office is a noble pursuit. Do we have problems in the criminal justice system? Of course we do. Our message is really simple. Come help us fix it. So our doors are open, our arms are open, and we would like to embrace people of every hue and ethnicity. But we want good people who would be vigilant to our ethos and be true ministers of justice.
Mr. Griffin, Mr.
Certainly.
Griffin, if you're hiring, please send me your job announcement. I got some wonderful students that are graduating. I would love to join your office.
Listen, I would certainly do that, and I would go one step further. If you would like a presentation on campus from myself or members of my staff, we would be happy to do that. We plan on having an open house here at the Division of Criminal Justice in October for law students. And we would like to show what the Division of Criminal Justice is all about, what we're doing, what steps we're taking, what direction we're going in. So I would take you up on that, Professor.
I appreciate that, Attorney Griffin. I know you are interested in trying to bring about necessary reforms, and make sure you let them know what the salary is too.
Professor Davis, we're recruiting as well, so let me know too.
Oh, definitely. I definitely have some public defenders that I can send your way. I'll be in touch with you.
Thank you.
I think the program calls for us to allow the audience to ask some questions. Now, I don't know how to work this chat stuff, so.
So Justice Harper, there are a number of questions and comments in the chat box, so if everyone can look at them, but I could read out a few of them for the panelists, and I'll just throw out some, but everyone can take a look. All right, so one that was asked, can you address the use of mandatory minimums? Anybody can take that.
Mandatory minimums, taking away a certain amount of discretion. Who wants to address that? They good, they bad, do we need them? Does it contribute to disparity? Does it eliminate disparity because we eliminate some discretion? What's the thinking?
Okay.
Anyone?
Okay, so mandatory, okay, no, go ahead, please.
No, go ahead, Ms. Bain.
I think mandatory minimums is a double-edged sword, right? It could be good and it could be bad, right? It's do we need them? Okay, so everyone wants justice and everyone needs justice. When a crime was committed, then we should look for some type of reprimand from that crime being done, right? But the mandatory minimums can be harmful if it doesn't suit the crime, right? And it could be harmful if you have other mitigating factors. Because there's people that commit a first offense crime, right? And they get a mandatory minimum for the crime itself because it was a crime that was committed. But then they have children, they have loved ones, they have elderly parents that they're looking to, that they take care of. And that right there then starts the ball rolling and dismantles the household itself. So I think mandatory minimums can be weighed and can be looked at as an oxymoron. And I don't think we should have them, but I think that sometimes they do work, if that makes sense.
They're problematic. Problematic. They definitely are. And it cuts away from discretion, right? From both the prosecutor as well as the judge. So they're problematic.
I think they should be absolutely eliminated entirely. I'm going to take it even further. The mandatory minimums came out, and particularly when we talk about Congress, it's interesting because the motivation behind it was supposed to be about treating everybody the same. And even in the Congress, we had Black congressmen supporting them, like, oh, we don't want the judges to be giving, white defendants lower sentences. They're all going to get the same sentence. Well, the problem was it got rid of the discretion of the judge, and gave even more discretion to prosecutors, because then prosecutors were in the position where they were the ones who decided whether to reduce a charge down from a mandatory minimum to not a mandatory minimum. And so I think it does not allow judges to take individuals into account. If they get convicted of a mandatory minimum after trial, the judge has absolutely no discretion. And so I think they're a bad idea. I think people should be sentenced individually and not charges, right? So you know.
I agree with that. Let me put my 2 cents on it. Because I think each case is different, and I want to make a decision that's appropriate to that individual and the circumstances surrounding the reason why he's involved, he or she's involved in the system. Another question, Attorney Moore?
So it's a comment and a question. It bothers me when a prosecutor offers a relatively mild penalty as a plea deal and the defendant does not agree, and then the prosecutor goes for a severe penalty at trial. If the prosecutor feels that the penalty offered as the plea is appropriate, why go for more at trial? Does that not penalize the defendant for exercising his constitutional right to a trial?
That's the exact description of the trial tax. Many people feel that that's not a concept, it's not true, and it is. And that's a perfect example of what that is. It's harmful, and it is problematic as well too. And it's something that prosecutors need to think about, as well as judges, when we're negotiating in those pretrial situations.
Well, if I might just add, the pretrial judge who accepts or rejects an offer would not be the same judge at the time of sentencing at a trial. And there are additional factors that should be taken into account. For example, an individual who takes responsibility and thereby keeps a victim from having to testify, particularly say if we're dealing with a sexual assault or a small child, that defendant should get the benefit of a bargain. On the other hand, if that defendant chooses to go to trial, the factors have changed. So, I think it's overly simplistic to tag this as a trial tax, because I do think that there are circumstances and facts that do change post-trial. But I also agree that a prosecutor should be mindful of what his or her pretrial offer is when making recommendations post-trial. I don't disagree with that. But overall, I just don't. I'm hesitant on this one, because I do think it's oversimplification to just say trial tax without taking into account factors that have arisen during and post-trial.
I don't agree that there are a lot of differences that occur between the rejection of an offer and when we begin trial. We both have had many, many trials, and we all who are litigators know that there are not that often, that there are many huge differences that would really occur between those 2 stages. So I understand your stance on that, but I do believe that the trial tax does exist. I've seen it with my own clients many, many times. And of course, some things do change. I'm not saying that they do. But overarching, I don't think that is necessarily true universally.
Is that misconduct?
Not legally.
I was just going to ask that.
It's not legally, courts will not find that to be misconduct.
Thank you. Any more questions? And I know our time is running short, and I want to give. I'm sorry.
2 questions. What kind of training are prosecutors receiving on behavioral health care? I'm aware that the Public Defender's Office have social workers and/or clinical workers to help educate. Isn't it time for the entire legal community to learn of issues of therapeutic jurisprudence? So Pat, I guess that's to you.
Yeah, it's a great question. And it's something, one of the first steps that I took, Attorney Ogilvie, after being appointed, was to create a position, professional standards and ethics, an office here in the Chief State's Attorney, staffed by an Executive Assistant State's Attorney. And one of her duties, it's Lisa D'Angelo, is to come up with a comprehensive training regimen across the 13 judicial districts. And one of the issues that we are discussing is behavioral health and incorporating behavioral health as an aspect of our training division-wide. We're committed, besides our statutory and bar obligations, we're committed to providing 3 hours of individualized training per month from the Office of the Chief State's Attorney. So I think over the coming months, that is certainly something that our folks are going to be afforded.
Thank you. And another question. The public has an interest in knowing what happens in criminal cases and in the criminal justice system. Should prosecutors and public defenders be holding more trainings about the overall criminal justice process for the public?
Of course. And that's, I think we could both say that those things are in the works, but of course, definitely.
And in potentially, I think I can say Deshaun and I would be willing to do some trainings together. I think there's been some initial discussions about that. Because I think that one of the things about Connecticut's criminal justice system that people don't know is the degree of cooperation between prosecutors and particularly the public defender's office. We don't agree on everything, and we shouldn't. It's an adversarial system, but we agree on many things. And one of the things I think moving forward is to show the public that level of cooperation. Agreed.
I want to take a few more. I know our time is running short, but what I want to do is give each panel member an opportunity to make a concluding statement, and that includes your brilliance, Professor Davis. Do we have one more? Can we take one more question from the chat, and then I'd like to give the panel members an opportunity to make closing remarks.
I think we can segue to the panel members.
Okay, each panel member, Ms. Bain, you would like to make some closing remarks?
Yes, I just want to say thank you to the Connecticut Bar Association and the Motley Speaker Series for having me today. This has been a wonderful experience to sit on a panel with all you wonderful, bright-minded individuals, attorneys, and prosecutors. Someone couldn't have told me that I would be here today, 20 years ago. So I just want to say it was a pleasure to actually be in a conversation with all of you. And I hope to meet you guys in person. I met you before, Justice Harper, in person at the grade 8 induction last year. So I did meet you briefly, but I would love to be able to actually, be of service to anyone that would love to have me. And thank you. I appreciate it.
Well, thank you. Your participation has been invaluable. Tashawn?
Again, thank you all. It's been a wonderful opportunity for me and for my division. It's been a great opportunity to be on the panel, and just remember the power of discretion. I mean, 2 great examples would be in the Khalif Browder case from New York, as well as the exonerated 5. Those are 2 very high-profile cases where prosecutorial discretion could have been used and should have been used. And so with that, thank you. And I look forward, Pat, to working with you and your agency in a collaborative way in the future.
Thank you, Tashawn. Thank you for your participation, Pat.
Well, thank you. And Tashawn, I echo your sentiments, and I look forward to working with you and your staff as well. As the administrative head of the Division of Criminal Justice, I've sought from day one to prioritize working with the state's attorneys, the 13 state's attorneys, in a collaborative manner for the development and implementation of policies and procedures and strategies, not for one judicial district, but for the entire Division of Criminal Justice. Our fundamental goal has got to be regarding policy development to promote public trust in our prosecutorial decisions and in the exercise of our prosecutorial discretion. We've got to continue to work as hard as we can to assure the public that our decisions are based on a rational and objective evaluation of every single charge in every single case. And I think we need to strive to use our discretion so that similarly situated victims and defendants are in fact treated equally, and to seek outcomes that are consistent with what we can call fundamentally fair and efficient administration of justice. And so to that end, we have prioritized the development of important policies and initiatives. Over the last few months, we've upgraded our Brady and Giglio policy. We've created a position, as I've indicated, for Director of Professional Standards of Ethics. We're working on our Connecticut's first prosecutorial standards and rewriting our ethics policy. We're supporting early screening intervention. We're supporting the Moving Justice Forward initiative. So I'm optimistic about the human capital that we have working with the Division of Criminal Justice. And I hope that we can, through these types of forums, assure the public that we're working as flat out as hard as we can to try to end disparities within the system.
Thank you very much, Pat. I know you're committed to doing that. Professor Davis.
I just want to say thank you and express gratitude for inviting me, allowing me to participate in this program. I get asked to speak on a lot of panels, but I have to say this is one of the best programs, and I'm not just saying that I've participated in, from the great information that Kyle and Mark presented at the beginning to the expert moderation of the panel and the great questions by Justice Harper to the wonderful contributions of all of the panelists. It's rare that I'll get to be on to see and observe a panel with the chief public defender and the chief prosecutor, and for you to have the foresight and wisdom to include Ms. Bain, because so many people do not include formerly incarcerated people who are in leadership positions out here, whether they're in leadership positions or not. But the fact that Ms. Bain is both a leader and has had that experience, and we need to start including people like her in these panels, and her contributions to this panel just prove that. So thank you all very much for allowing me to participate.
And thank you also for your brilliance and your contribution was certainly significant, and the topics that you talked about are certainly the topics that needs to be discussed throughout the country with respect to criminal justice. And I would like to thank the panelists in particular. I mean, I happen to know Sashan and Pat, and I did meet Ms. Bain. That's right. Last year, when I spoke at the Hall of Change, and Moy Ogilvie, who forced me to become the moderator. So I want to thank all of you, and also the planning committee. You did a wonderful job, and I got to tell you, the topic is certainly a timely topic. And the Connecticut Bar Association and the Connecticut Bar Foundation for their assistance in putting on this worthwhile program. Thank you to everyone, and good evening.
Just briefly before we go, thank you all for joining us tonight for this session of the Constance Baker Motley series. Thank you again to Justice Harper for moderating, our keynote speaker, Professor Davis, and for all our speakers and presenters and panelists for sharing their knowledge and expertise. Thank you again to the organizers and the working group for this session, as well as the Connecticut Bar Association and Connecticut Bar Foundation. Please follow and subscribe and get the newsletters for the CBA and the CBF communications for more information about this series and upcoming events. Our next session will take place in the third week of November, and we'll focus on inequities in special education in Connecticut. Thank you all again, and thank you so much for coming. Enjoy the rest of your evening.
Thank you.
Thank you.